1955. Hindu Marriage Act 1955. 1955. Hindu Marriage Act 1955. What is the main intention behind the enactment of this act అనేది మనం ఫస్ట్ తెలుసుకోవాల్సిన పరిస్థితి ఎంతైనా అవసరం ఉంది. Why? Because to enact an act, there is a long discussion. There will be a long discussion by the enactors. That means ఈ యాక్ట్ని ఎందుకు, what is the purpose of enacting this act అనేది statement, reasons and objectives we have to go through first. This act is, as we discussed from the act, we can see that the we can see that as seen from this act itself, we can see that the act is of the year 1955. What is the situation prior to 1955 అనేది మనం ముందుగా తెలుసుకుందాం. So the situation prior to 1955 is there is polyandry and polygamy. అంటే polyandry, polygamy అంటే ఏంటంటే ఒక మగ వ్యక్తి ఎంతమందినైనా పెళ్లి చేసుకున్నటువంటి పరిస్థితి ఉంది. అలాగే ఒక ఆడ వ్యక్తి కూడా ఇద్దరు ముగ్గురు అంతకు మించి వ్యక్తులను కూడా పెళ్లి చేసుకున్నటువంటి పరిస్థితి ఉంది. బట్ దెర్ ఈస్ నో స్పెసిఫిక్ రెగ్యులర్ కోడ్ ఆర్ సంథింగ్ ఎల్స్ యాక్ట్ which regulates the marriage institution prior to this Hindu Marriage Act. So to streamline the process and to provide some sanctity to the marriages, this Hindu Marriage Act has been introduced by way of a bill into the parliament, and it has got the assent from the president on 18th May 1955. On the same day itself, this act has came into force. The act number is 25 of 1955. Act number is 25 of 1955. So why I'm stressing about this specifically means the persons who are interested to become judges, junior civil judges, for this numbers, I mean the number of the act as well as the date on which the act has came into force is very important. So please note this. The date of commencement of this act is 18th May 1955. 1955. On the same day itself, after receiving the assent from the president, this act has came into force on 18th May 1955. And this is the 25th act of the year 1955. Please note it down. Okay. So now coming to these sections, how many sections that are covered in this means there are nearly 25 to there are 28 sections. 28 sections is 28 sections are there in the Hindu Marriage Act. So one by one we are going to discuss. First section is that short title and extent. What is meant by short title and extent means the nomenclature of the act, title of the act. What is the title of the act means we know that this act is called as Hindu Marriage Act. This act is called as Hindu Marriage Act. And what is meant by extent? Extent means to which area, from which area to which area this is applicable, and to what is the area of application. That means to which extent this code is going to apply. That will be discussed in section 1. So if we read from section 1, that is short title and extent. In the opening lines of the act itself, it is clear that this act may be called the Hindu Marriage Act 1955, and it extends to the whole of India except the state of Jammu and Kashmir, and applies also to the Hindus domiciled in the territories to which this act extends, who are outside the said territories. So while we are reading this section 1, subsection 1, it is clear, but there is no ambiguity. When it is coming to section 1, subsection 2, this act extends to whole of India except the state of Jammu and Kashmir, and applies also to the Hindus domiciled outside the territories of India. That means what is meant by let us have a discussion on section 1, subsection 2 now. So in this subsection 2, it is we can see that this act is applicable to whole India except to Jammu and Kashmir. Now, after dissolving this Article 377, this act is made applicable to all over India, including the Jammu and Kashmir. Now, coming to the second part in this subsection 2 of section 1, we can see that the territories it applies to the Hindus domiciled in the territories to which this act extends who are outside the said territories. So here we can read that the words, that is Hindus domiciled in the territories to which this act extends who are outside the India. That means, what is meant by domicile? Domicile is nothing but the person's legal address of a person. Person's legal address, that is permanent legal address of a person, is nothing but domicile. That means, for example, if A and B are married in India, who are permanent residents of India, permanent legal residents of India, have got married in India, but they are residing currently at United Kingdom or somewhere else. So here we can see these persons have after the marriage, they have got some disputes in their marriage institution, marriage life, and they want to break the marriage. Now, in this case, what will happen means, both are Hindus, but they are residing at outside the country, but their permanent address is of India. Here, as per the general rules of international personal laws, so the law of domicile will be applied. That means the domicile here is A and B are domiciles of India, and their law is relating to the Hindu Marriage Act. So even the persons who are residing outside the territories of India, but who are domiciled in India, for them also the Hindu Marriage Act applies. So this should be understood clearly. If anybody is having doubts, you can ask me at the last. Please note it down if you are having doubts, please. Coming to section 2, which is application of the act. Application, wherein on plain reading of the section 2, we can understand that to whom this act is applicable. We can say this Hindu Marriage Act is a personal law. Personal law means this a law which is specifically the law which is specifically applies to the specific religion, like Hindu Marriage Act, Hindu Succession Act, Mohammedan law, Christian Marriage Act. So these are the laws which are meant for specifically some religion, that like which act we are discussing now. So this is the act which is specifically enacted for the Hindus. So we can call this act as a personal law. Moreover, in this section 2, application of the act. That means to whom this act is going to apply, that is discussed in this section 2. So from section 2, subsection 1, if we read that, this act applies to any person who is a Hindu by religion in any of its forms or developments, including a Veerashiva, a Lingayat, or a follower, or a Brahmo, Prardhana, or Arya Samaj. That means any person who is a Hindu by religion. So this act applies generally to all the Hindus by religion. Next, including Veerashivas, Lingayats, the followers of Brahmo, Prardhana, and Arya Samaj. So to this set of persons, this Hindu Marriage Act is applicable as per section 2, subsection 1A. Coming to subsection 1B, to any person who is a Buddhist, Jain, or Sikh by religion. To any person who is a Buddhist, Jain, or Sikh by religion. And coming to subsection 1C, to any person domiciled in the territories to which this act extends to any person who is domiciled in the territories to which this act applies, who is not a Hindu, who is not a Muslim, coming to this subsection 1C, to any other person domiciled in the territories to which this act applies, extends, who is not a Muslim, who is not a Christian, who is not a Parsi or Jew, Jews by religion. So unless and until he is proved that he is belonging to some other religion, he is presumed to be a Hindu. He presumed to be a Hindu as per the subsection 1C of section 2. So this act is applicable to entire India. I mean the entire persons who are domiciled in the India, and this act is applicable to the persons who are not Muslims, who are not Christians, who are not Parsis, who are not Jews, and to all the persons until the contrary is proved that he is not belonging to the Hindu, like that. So in this way we have to understand the subsection 1C. Now coming to the explanation that what explained in this section 2, that is, the following persons are Hindus, Buddhists, Jains, or Sikhs by religion, as the case may be. So now who are Hindus? Now we can see any child, legitimate or illegitimate, born to the Hindu parents. So when the case A, for example, if A and B are Hindus, if the child is born, so the child is a Hindu by birth. He become a Hindu by birth. In second case, if A is a Muslim and B is a Hindu, if the child is brought up and raised as per the Hindu religion, then he by the mother, that is B, so he will become a Hindu, or by conversion or reconversion. So by conversion, that means if a Muslim person wants to profess the Hinduism, he wants to follow Hinduism, if he accepts the Hindu, then he will become, if he converts by following rituals, he will become Hindu. If any person who has converted into a Muslim, from Hindu to Muslim, again he converted back to Hindu, then he will become a Hindu. So conversion and reconversion, the person who has converted from his religion to Hinduism, or who has reconverted, again converted, also becomes a Hindu. So these things are discussed in this subsection 1. And now coming to subsection 2 of section 2. This Hindu Marriage Act is not applicable to the scheduled tribes who are discussed under Article 366, subclass clause 25 of Indian Constitution. So if we read this Article 366 subclass, clause 25, there is a referral about Article 342 in the Indian Constitution. What is Article 342 in Indian Constitution means? So the government of that specific area, as per consultation with the president of country, so they are going to identify that a set of persons are belonging to scheduled tribes. So for scheduled tribes, there is no application of Hindu Marriage Act. They will be having special laws as per their locality, that means tribal areas. So they are not applied with these laws. So they will be having some separate laws. So if any government wants to apply this Hindu Marriage Act to that specific scheduled tribe areas or specific persons of specific set of tribe, so then the government first has to issue a notification in the public gazette, government gazette, that so-and-so act is applying to the separate set of the scheduled tribes. Then it will be applied. So without making a notification in the gazette, no, this act cannot be applied